docket this morning, or this afternoon, excuse me. Are both sides ready? You may proceed.
May it please the court. My name is Jasmine Russell, and along with my co-counsel Stephen Sullivan, we represent Mr. Brandon Wilson. I would like to reserve 5 minutes for rebuttal.
Okay, I'll try to remind you, but you'll be responsible because the clock's in front of you.
Yes, sir. This case stems from the summary denial of a motion for post-conviction relief where Mr. Wilson alleged that he had a complete defense to the charge of burglary that was utilized to support the state's phony murder theory. The trial court summarily denied the motion and found that Mr. Wilson's argument relied on cases that were decided before the 2001 amendment to the burglary statute. The court found that even if he had consent for the initial entry into the parking garage, that once he attempted to commit a robbery, that his consent to enter had been withdrawn. The trial court also found that trial counsel did object and argue that Mr. Wilson could not be guilty of felony murder based on an allegation of burglary. Therefore, his claim was without merit. In order for a defendant to establish that he received ineffective assistance of counsel, he must demonstrate that counsel's performance was deficient and he was prejudiced by the deficiency. I will discuss each prong in turn. Defense counsel was ineffective when he failed to object to the erroneous felony murder jury instruction, which was based on the predicate offense of burglary because the parking garage was open to the public at the time that Mr. Wilson entered with the intent to commit an offense therein.
Counsel, can you think of a strategic reason why that wouldn't be argued in this case? Meaning the defense was concerned about the premeditation part of the state's case and chose for strategic reasons not to advance this defense?
Your Honor, I can think of no conceivable reason why a defense attorney would not raise an affirmative defense to a crime, because if the defense was raised, then the state would have only been able to rely on the premeditation theory.
But you know the case is going to the jury, correct? You've got a jury in front of you, and knowing the vagaries and vicissitudes of juries, could that not be a strategic call by counsel?
Your Honor, I would maintain that it's not a strategic reason not to raise an affirmative defense. I think if the jury was given the opportunity to rely on the affirmative defense, they would have had the decision to decide, was the parking garage open to the public? They would have had the opportunity to say yes. And then, did Mr. Wilson enter an area that he knew or should have known that was not open to the public? And they would have found that he did not. Therefore, the state's phony murder theory would have failed.
What? Go ahead.
Go ahead, Judge.
No, I was just going to say, if we find that this may have been a strategic, and I'm not saying it, we're going to find that way, should we reverse this for a new trial, or should we just send it back for the trial court to hold the hearing?
I would maintain that this should be sent back for a new trial instead of a hearing on the motion.
But if we can, isn't it true that if we can conceive that there's any strategic reason or potential strategic reason that there should be a hearing in front of the trial judge to explore that?
Correct, Your Honor, that is correct.
Okay, so that would not, I mean, I don't want you to concede that there is a strategic reason, but I'm just saying if we find one.
Correct, so if you did find that there was a strategic reason not to raise the offense, like Counselor just led about concerns about the premeditation theory, then yes, you can send it back for a hearing on the motion.
So does your whole case hinge on a conclusion that the entry into the parking garage was not licensed or invited entry? I mean, the statute talks about open to the public, and then it talks about licensed or invited entries. Are there, one, if we concluded that there was a licensed or invited entry, does that kind of end your case? And if not, why not?
I think that the license or invited entry is a separate category from the open to the public. I think if the court were to find that license or invited and open to the public is the same thing, then that would defeat my argument. However, I would argue that the statutory language would be ambiguous, and that any ambiguity should be construed in favor of Mr. Wilson.
So are there categories of things that are both open to the public and for which there'd be an invited entry, or are they completely independent things in all circumstances?
I think there are circumstances where a premise that is open to the public can qualify as a license or invited entry. For example, if a defendant enters an area that indicates that this is an employee-only area, then his open to the public affirmative defense would fail at that point because he entered that restricted area.
Yeah, and what I'm struggling with is, you know, some of the cases talk about, invited entry at a party or a home or something like that.
Correct.
And then some of the cases talk about open to the public in terms of a store, and sometimes under property law, you think of a store as being, kind of an implied license to enter, if you go into a drugstore or something like that, or business invitees. And then here we have something different, which is a, public parking garage or quasi-public parking garage, and I'm just struggling to understand where that line is between something that's open to the public and something that's a licensed entry.
So I think this is demonstrated in a case called Dukas versus State, where the court held that Dukas's actions of robbing a pharmacy could not also qualify as a burglary, where it was undisputed that the pharmacy was open to the public and he did not enter a restricted area inside of the pharmacy. And here, the fact that the parking garage was open to the public was undisputed and conceded by both parties during the trial. Also, the state did not introduce any evidence that Mr. Wilson entered an area that he knew or should have known that was not open to the public. Therefore, defense counsel's performance was sufficient.
Was your client impliedly invited into the parking garage?
Your Honor, I think the evidence is that the parking garage was open to the public, so therefore anyone would have an implied reason to or permission to enter into the parking garage.
So to follow up on Judge Windsor's question, because there may be an overlay here, why wouldn't the notwithstanding a licensed or invited entry apply?
I would argue that the notwithstanding a license or invited entry would not apply because the parking garage was open to the public. And the only limitation on that is whether or not he entered an area that he knew or should have known that was not open to the public. Also, the amendment to the burglary statute did not defeat the open to the public defense because there are several cases post the amendment that have applied the open to the public defense to a crime of burglary.
Have those cases, though, taken on the implied invited entry, where you have a situation, and it's standard property law, say a Target, it would be open to the public, but impliedly you're an invitee on those premises. So just the interplay between those, I didn't see that in any of the cases, unless I missed that. And
So the same, I did not see that as well.
So what would you make of that? Again, my Target example, someone goes into the Target, even though it's open to the public, but under privacy law, they are an invitee. They are impliedly invited to look around the store, and then while there, they commit a forcible felony. Would it be your position that would not be a burglary?
Correct. That would be my position, that it would not be a burglary because they are inside of a public place. Unless they enter a restricted area inside of that public place, then it would qualify as a burglary. So I would argue that Mr. Wilson was then prejudiced by counsel's failure to raise his affirmative defense because the jury returned a general verdict finding him guilty of first-degree murder, but no determination as to what theory of prosecution that was applicable. And a conviction that rests on alternative basis, one of which is legally inadequate, cannot be upheld where a general verdict makes it impossible to say that a defendant was convicted under a legally adequate theory. If there are no further questions, I will reserve the remainder of my time for rebuttal.
May it please the court, Tricia Meggs Pate representing the state of Florida. In this case, the legislature overhauled the burglary statute in 2001.
Okay, before you go into the 2001 amendment, if this case had occurred prior to the 2001 amendment, would you concede that the other side would win at that point?
Absolutely. And that's what the legislature overhauled it because the Florida Supreme Court, analyzing the statute, said open to the public before 2001 was a complete defense to burglary.
Okay, what about specifically in the 2001 amendment change? If I look at the wording, it looks like the new language talks about the portion that says licensed or invited to enter, but it also has an or for places open to the public. And the new language that was added just refers to the licensed or invited, but does not mention open to the public.
I think I can explain that. In 2001, the legislature overhauled the statute in response to the Delgado case, which mostly addressed burglaries where people were invited into a home, and then they did so with the intent
And
to
Delgado
commit
was a home, it wasn't a place
home.
open to the public.
Right, and they said it had to be surreptitiously remaining in order, consent could not be withdrawn because you're committing this forcible felony. One of the concerns in the Delgado opinion was the fact that if we don't have this language, we will create anything into a burglary. So to use your Target example, if I go into Target with the intent to shoplift and commit a petty theft, that would become a burglary if there were, because you're going into a structure with the intent and there's no remaining in language or surreptitiously remaining in, and you're invited in there. And so the legislature, I think, in response to those concerns, because Delgado mentions going into a house party to smoke pot, is that a burglary? Or going into a pizza place to fraudulently obtain a pizza by writing a bad check, those would become burglaries if we didn't have these qualifiers. And so the legislature, in response, did the license invitee entry to overrule Delgado to make it, if you enter into a public place with the intent to commit a forcible felony. So if you're a licensed invitee to enter, and you enter with the intent to commit a forcible felony, that is a burglary. But if you enter a place still open to the public, if I enter Target to steal a $5 object, that is not a burglary. So I think the open to the public language remains for non-forcible felonies that don't meet those exceptions, but they've carved out an exception for license and invitees. And I think under general property law, if something is open to the public, it is a general license. Let's take the parking garage, for instance. Many parking garages charge fees to enter, so the public at large is available to go in there if they pay the fee. Or if, the parking lot is full, you may have a right to enter when it's not
Wasn't
full.
really the part of Delgado the legislature was trying to deal with was the surreptitious language?
I think most of it was a surreptitious language, but they added to the 3 exceptions to the consent to enter language was surreptitiously remaining in when consent is withdrawn, or if you enter to commit a forcible felony. So that was one of the exceptions that they did allow. And I think you have to define open to the public, like the shopping mall examples that I put in the brief, the hospital, those places are open to the public.
What if I go into a public, well, that's not a structure, I'm thinking about a public park, but a stadium with a roof. And I just go in there with the intent to commit petty theft. Or, no, I'm sorry, it should be a forcible felony.
And it has to be a forcible felony,
felony.
and I think that's the difference, and that's why open to the public, if you go into a structure, a stadium with the intent to commit petty theft, it's not a burglary.
But what about, say, a 7-Eleven? Because some of our cases talk about, the store was open to the public, with using the term open to the public as opposed to a business invitee. What would your position be if someone went into a 7-Eleven? Is that open to the public? And does that exempt them from, is that a defense to burglary? Or is your position that open to the public and business invitees are kind of one and the same?
I think it's one and the same. So if they enter the 7-Eleven to commit a misdemeanor, it's not a burglary. If they
So
do
why
that
is
with the intent
language,
to
if
robbery.
that would be a license or invited to enter situation, why do we even have the language in there unless the premises at the time are open to the public? I don't understand,
Well, I think
those
it's.
would be superfluous words.
I think it is a little superfluous, but I think then you have to, if you find that the legislature intent is not clear, I think they could have meant that the open to the public is still a defense if it's not a forcible felony, to make that clear. I think that's what they intended, but if you find.
Say that again, I'm not.
I think they included the open to the public language because if the place is still open to the public, if you go in Target to commit a misdemeanor, a petty theft, that's not a burglary. And I don't think the legislature intended by adding these exceptions to make that a burglary. But if you go into Target with the intent of committing an armed robbery, which would be a forcible felony, then it does also become a burglary. So they wanted to treat these more serious crimes more seriously. So I think that's why they could have. But if they don't, then you look at the legislative rules of statutory construction, and I think the more specific exemptions would control over the general language in the first part of the new part of the statute.
Okay, can you, I'm going to switch gears on you for a second.
Okay.
Can you think of any legitimate strategic reason not to knock out one or two possible ways that you could be convicted?
Well, I think he tried to get what he thought was the stronger argument, that there was not a lot of evidence of the intent to commit the robbery, because the co-defendants had made several statements to the police that they were intending to commit a robbery, and then they got amnesia when they got on the stand. But I think in that case, I think it was conceded that this was a public parking garage, not necessarily open to the public. They could be synonymous, they may not. It may be a private parking garage that charges a fee.
Was there any indication of any of that?
There's not, but this is a parking garage that's right across the street from the courthouse. This happened right around the courthouse, so they would be very familiar. There could be signage in that parking garage saying
Say
no
there could be,
loitering.
but unless you have something on the record to
But
indicate
you're
that-
asking me why council wouldn't have objected.
Yeah, that's what I'm talking
Council
about.
may have known, hey, this parking garage charges a fee to enter. This parking garage has numerous no trespassing or no loitering signs around that, which may defeat the public. The state may have had strong rebuttal argument that this is a public parking garage, but it wasn't open to the public. It may have hours of
No, but
entry.
I'm saying, why did they even let the instruction be given or even let the state argue? I mean, the indictment here only charged premeditated murder. It did not charge, the felony murder. What would be the strategic purpose for letting felony murder go to the jury? It just seems like another option that the state can argue to find somebody guilty of first-degree murder.
Well, I think, I don't have the case law right in front of me, but I think if you charge a premeditated murder, the state, I think there's case law supporting the fact that you can also argue felony murder. I can file supplemental authority on that. But I think the state does have that option when there's an indictment for.
Well, they could have charged it, but they didn't here, did they?
They didn't, but I think there is
So if
case law.
something's not charged, what is the purpose of allowing that even to go to the jury or even let the state argue it?
I think there is case law that allows that to happen.
What happened, to amend during the middle of the trial?
No,
like-
when you
like-
charge first-degree felony murder, when you charge first-degree premeditated murder, there's case law from the Florida Supreme Court that also supports you can give the alternative theory of felony murder to the jury.
Okay.
But there's no argument here that would have been a basis for ineffective assistance of counsel, even if you're not correct about that, which I think you are. I mean, I think the argument is that this particular jury instruction should have been allowed to support the alternate basis.
Correct,
right?
that's not the argument that was made below. That's not the issue that they're raising.
So what you were talking about before, I guess you were making the argument that there would be no prejudice if it turned out, for whatever reason, that as a matter of law, this person was an invitee or had, what's the statute say, a licensed or whether there's a licensed or invited entry.
Correct.
And so would you agree with me that this whole case turns on what we make of that as applied to this factual situation?
I think so. I think it's an interesting legal argument. I think there's 3 cases that have occurred subsequent to 2001 that really haven't analyzed the subsection of the statute. They just applied old
At
case
least
law.
in Dukas case, at least recognize that the statute had been changed.
Correct.
Okay.
But the three subsequent cases don't really analyze the exceptions or the license invitee exceptions. They just kind of follow old case law, the pre-2001 case law. And I think whenever you're looking at case laws, and I try to train my attorneys at least, go back and look at why. Why does the case law say this? What's the reason? And I think Miller and the pre-2001 cases, I think it's Byron or Breyer, they were interpreting the statute as it was written, which did have an exemption for open to the public. But that changed in 2001, and I think A licensed invitee, which would be open to the public, a general license and invitee to enter, if you enter with the intention to commit a forcible felony, it is a burglary under the new
But they
statute.
left, and I'm kind of arguing with you, but I'm playing devil's advocate here, but they left the language open to the public still in there, and then when they talk about the exemption, they say notwithstanding a license or invited entry. What would be the purpose of not also addressing open to the public?
I think that's because if it's open to the public, but you don't enter for a forcible felony, I think that's the only purpose they could have in leaving that. So if you enter a place that's open to the public, but you didn't have the intention to commit a forcible felony, which was a concern in Delgado, it was one of the concerns they had in the Delgado case, is anytime you enter a place, anytime you're inside of structure or a dwelling, does everything become a burglary? And they wanted to address that. So no, if you're an invitee or if it's open to the public and you enter without the intent to commit a forcible felony.
But they would have addressed that the same way if they would have just used the same language from the old existing statute, which was open to the public or the defendant is licensed or invited to enter, if they had just sort of grabbed that language and put it in the new created exemption, as opposed to just, as Judge Wolf is saying, grab just half of it, right?
It would have made my job a
That's
whole
right.
lot
So
easier.
that's the trick here. So can you think of anything that would be considered as a legal matter under this statute, open to the public, but would not be considered to have a licensed or invited entry?
There may be a place that's open to the public that you have as much right as anybody else. You know, I think this.
Like a sidewalk under or something. There
Something
wouldn't be
like that, a
structure,
covered
obviously, but-
sidewalk, maybe a structure, but you have as much right as anybody else. So there may be some type of structures. I think it would be very, very narrow, but there might be. Maybe a pavilion in a park, where they allow people to go sleep or something like that, that's still a structure, but it's not a restricted space. So based on the arguments that we've made in our brief, we would ask you to affirm. Oh, I did want to address the remedy. I think the remedy, I think there still needs to be an evidentiary hearing because counsel may have been, had reasons, you know, there may or may not be, but he may have reasons. He may be familiar with this garage, and I think they could put on.
Okay, so that would be the only reason to have a hearing.
Correct, but suppose this garage charges fees, suppose it's a public parking garage that charges fees to enter or something like that, which would boost the fact that they were licensed invitees to enter.
But your position, I know you talked about that in the brief, the parking garage is full, there's a fee, there's a machine, but your position, just so I'm clear, is that even if it were just a ordinary parking garage that said anyone can park here whenever they feel like it, no gates or anything, that would still be a licensed or invited entry? That's your
Correct.
position, okay.
All right.
And I had one other question on the Mackerly. As to the prejudice, the argument is that when there's two bases that go to the jury and one's not legally sustainable, there is per se error. I'm not sure whether Mackerly says that, I'm not sure whether the right reading of Mackerly is that it's not automatically not error because there was sufficient evidence as opposed to something broader that there can't possibly be a harmless error analysis when two bases go. Can you respond to that? Or
I think there can be a harmless error analysis. I know this case was kind of tough for either one because there's not a lot of evidence of premeditation as well as intent to commit a robbery. But I think in cases in general, there could be a very strong harmless error analysis.
Okay, are you saying there could be
There
in this
could-
case, or just could be in general?
I think there could be in general. I think in this case, there is some evidence that he shot one shot up in the air, then pointed directly at the victim and shot him, which I think is legally sufficient to support a conviction for premeditated murder.
And that's what Mackerly is clear about, that the legal sufficiency is not enough to defeat their claim. But my question was, could there be, something that was beyond legal sufficiency, just overwhelming, something that would meet on a direct appeal the harmless error standard, whether we would still, because of Mackerly, be obligated to find prejudice?
I think if you had a case where, especially if, say, the guy wrote a note, had tracking them, stalking him, following him to this parking garage, had out his plan, notes of how he was going to kill him, you had heightened premeditation, I think that would be pretty clear.
But you're not
Yeah.
arguing in this case?
I'm not arguing that this case is that clear cut. Thank you.
The state contends that the open to the public defense is no longer a valid defense under the current statutory scheme of the burglary statute. However, the state's position has no support in any case law. Also, there are several cases post the 2001 amendment that have applied the burglary statute, such as the Dukas versus State, Colbert versus State, and Capello v. State cases, which were resolved in 2012, 2010, and 2016. Mr. Wilson maintains that the statutory change to the burglary statute did not impact the open to the public defense. And here, the fact that the parking garage was open to the public was undisputed and conceded by both parties during the trial. Additionally, Mr. Wilson maintains that the jury returned a general verdict, finding him guilty of first-degree murder with no determination as to what theory of prosecution was applicable. Therefore, he was prejudiced by the deficiency. And this error was so serious as to deprive him of a fair trial, a trial whose result is reliable. There's a reasonable probability that but for counsel's errors, the result of the proceedings would have been different.
What if it turns out there were a fee to park there? Would that change your analysis on open to the public?
I think that if there was a signage that indicated there was a fee, then maybe that would impact the open to the public defense.
And so is that something that would require an evidentiary, further work below an evidentiary hearing?
It's possible that that could be resolved by an evidentiary hearing. However, according to the testimony introduced
Okay,
to the trial,
I'm sorry, you were probably getting to the answer to that. Go ahead, I interrupted.
sorry, but according to the evidence introduced during trial, there was no indication of any signage or any restricted areas inside of the parking garage.
And in an evidentiary hearing, the state couldn't produce new evidence
Correct, you're right.
that was not presented at the trial.
Based upon that, we would ask that this court reverse the order denying the motion, vacate his conviction and sentence, and remand for a new trial. Thank you.
Thank you. Okay, there being no cases further in front of the court will stand in recess. Thank you for an excellent oral argument.
All rise.